Introduction: Applying Agency Law to Real-World Risk Management. In the previous section, we explored dual agency and the challenges that arise when a brokerage represents both parties in a transaction. We discussed intentional dual representation, the dangers of unintentional dual agency, and the importance of obtaining informed written consent. While understanding the legal framework is essential, the practical application of these principles is where risk management becomes critical. Real estate professionals frequently encounter situations where misunderstandings about representation, compensation, or disclosure can lead to disputes. These disputes may result in consumer complaints, civil litigation, or disciplinary investigations by the Arizona Department of Real Estate. Effective risk management requires agents to recognize potential problems before they escalate and to implement practices that protect both the client and the brokerage. In the fast-paced Phoenix metropolitan real estate market, transactions often move quickly, and agents must remain vigilant to ensure that agency relationships are clearly defined, compensation is properly explained, and disclosure obligations are fully satisfied. By examining common risk scenarios and analyzing real-world examples, licensees can better understand how to avoid mistakes and maintain compliance with Arizona law. A. Dual agency pitfalls. Dual agency situations present some of the most significant risk management challenges in real estate transactions. Because the brokerage represents both parties, the agent must maintain neutrality while still facilitating the transaction. This balance can be difficult, especially in competitive markets where buyers and sellers expect strong advocacy from their agents. One common pitfall occurs when an agent inadvertently provides negotiation advice that favors one party over the other. For example, a listing agent in Scottsdale who represents both the seller and the buyer may be tempted to advise the buyer to increase their offer in order to secure the property. Providing this type of guidance could be interpreted as favoring the seller and may violate the neutrality required in dual representation. Another risk arises when confidential information is disclosed improperly. If the seller has privately indicated a willingness to accept a lower price, revealing that information to the buyer would violate the duty of confidentiality. Similarly, sharing information about the buyer's financial limits with the seller could undermine the buyer's negotiating position. To avoid these pitfalls, agents operating in dual agency situations must clearly communicate the limits of representation and document the consent of both parties. Maintaining transparency and professionalism helps reduce the risk of disputes or complaints. B. Compensation misunderstandings. Misunderstandings about compensation are another common source of disputes in real estate transactions. Real estate commissions are typically governed by agreements between brokers, sellers, and cooperating agents, but clients may not always understand how compensation is structured. For example, a seller in Chandler may assume that the listing agent's commission covers all services provided during the transaction, including services provided to the buyer. If the buyer's agent later receives a portion of the commission through a cooperative agreement, the seller may question why multiple agents are being compensated. These misunderstandings can lead to complaints if clients believe compensation arrangements were not fully explained. Arizona law requires real estate professionals to deal honestly and fairly with all parties under AAC, R4 281101, and clear communication about compensation is an important part of that obligation. Agents should ensure that clients understand how commissions are structured, who is responsible for paying them, and how cooperating broker compensation works. Documenting compensation agreements in writing and reviewing them with clients helps prevent confusion later in the transaction. C. Disclosure failures. Failure to disclose material information is one of the most common reasons real estate professionals face legal disputes. Arizona courts have consistently emphasized the importance of disclosure in protecting consumers during real estate transactions. The case Hill v. Jones, 1986, established that sellers and their agents must disclose known material defects that could affect the value or desirability of a property. Material defects may include structural issues, water damage, environmental hazards, or other conditions that could influence a buyer's decision. Disclosure failures may occur when agents assume that the seller has already disclosed certain information or when agents fail to review disclosure documents carefully. For example, a buyer purchasing a home in Mesa may later discover that the property experienced prior termite damage that was not disclosed during the transaction. If the listing agent was aware of the issue but failed to ensure that the information was disclosed, both the agent and the seller could face legal liability. Effective risk management requires agents to review disclosure documents carefully, encourage sellers to provide complete information, and document the delivery of disclosure forms to buyers. Clear documentation of disclosure delivery can help demonstrate compliance if disputes arise after closing. D. Legal hotline Q&A review. Legal hotlines provided by professional real estate organizations frequently address questions related to agency relationships, disclosure obligations, and transaction disputes. Reviewing these questions provides valuable insight into the types of issues agents encounter in real-world transactions. One common hotline question involves situations where a buyer contacts the listing agent directly and requests assistance writing an offer. If the listing agent provides detailed advice without clarifying that the agent represents the seller, the buyer may believe that the agent is acting as their representative. This misunderstanding could lead to claims of unintentional dual agency or misrepresentation. Another common question involves disclosure timing. Agents often ask whether certain information must be disclosed if the issue has already been repaired. Legal guidance generally emphasizes that material information should be disclosed even if repairs have been made, particularly if the issue could affect the buyer's decision to purchase the property. Reviewing these scenarios helps agents recognize potential risks and reinforces the importance of clear communication, documentation, and adherence to professional standards. Discussion questions. Why are dual agency situations considered one of the highest risk areas in real estate transactions? Answer: because the agent must remain neutral while representing both parties, which limits advocacy and increases the potential for conflicts of interest. How can misunderstandings about compensation create disputes between clients and real estate professionals? Answer: when clients do not clearly understand how commissions are structured or how cooperating brokers are compensated. Why is proper disclosure considered one of the most important responsibilities in real estate transactions? Answer: because failure to disclose material defects can mislead buyers and create legal liability for both the agent and the seller.